The next matter before the court is Henry versus Henry. We have everyone here.
Yes, Your Honor.
That wants to be here. As you know, each side will have 15 minutes. The appellant may reserve up to 5 minutes for rebuttal. If you wish to reserve any time, let me know. I will give you a signal when you're getting to your end of your first period so that you can conserve the rest of your time. You may begin.
Good morning, Your Honor. May it please the court. My name is James P. Reddy, Jr. I'm here from the law office of Joyce E. Barrett on behalf of the appellant, Suzanne Henry. At this time, I'd like to reserve 3 minutes of my time for rebuttal. Thank you. Your Honors, it's a difficult position that I stand in today before this court in arguing a case on behalf of my client when I was not trial counsel. Two different lawyers preceded me that tried the case and also dealt with objections and motions to stay and whatnot. And also, nor did I prepare and file the appellant's brief in this case. But nonetheless, I'm here, and I think the court should be aware that some of the factual background that the parties had commenced a divorce trial and came to an agreement, and it stipulated as to what the terms of that agreement would be. Following the trial, they proceeded with the issue of spousal support. They did not have an agreement with spousal support, yet they presented testimony to the magistrate. And on a magistrate's decision was issued March 11, 2013. However, prior to that, a judgment entry was submitted to the court that was signed on March 1st, 2013. That decision, the judgment entry that was of divorce, contains a reference to signature line for both counsel for plaintiff and counsel for defendant in the case. There's no signature lines anywhere on the document for the parties. The document was prepared by counsel for defendant and submitted to the court and was actually signed by the court and filed on March 1st, 2013. However, the only signature of the court that appears on there is the judge. Under Civil Rule 53, that case had been referred to a magistrate, Magistrate Cable in this case. At Magistrate Cable, there's actually a signature line for Magistrate Cable on the divorce judgment entry, but he didn't sign it. So I submit to the court and the other issue in the case is the record is devoid of any waiver of Civil Rule 53 with respect to the judgment entry of divorce. Yet, on March 1st, 2013, divorce entries is issued. It had all the terms requisite in a divorce, except they reserved the issue of spousal support. The issue of spousal support was then, the decision was rendered on March 11th, 2013, by the magistrate that tried the case under Civil Rule 53. That magistrate, the decision was adopted by the court on March 11th, 2013. The entry adopting the magistrate's decision references the magistrate's decision from February 7th, 2013. It clearly states that in the judge's order. However, the docket there contains no magistrate's decision of February 7th, 2013. Had there been a magistrate's decision, had it been issued on that date, appellant would have had the opportunity to file objections to it prior to the court's adopting of it on March 11th. The March 11th ruling of the trial court references a February 7th, 2013 magistrate's decision and says it's attached to my decision. Well, the document that is attached is filed March 11th, 2013. There is no filing March 7th. So again, the defendant was unable to object to the findings of the court at that time. And what's key here, Your Honors, although it's different decisions, the procedural aspects of this case is convoluted, and I wasn't a part of it, but I'm trying to sort through it, as I know Your Honors have to as well. But the March 11, 2013 entry makes the divorce entry a final appealable order. Yet the court entertained objections to the March 11th, 2013 magistrate's decision, which had already been incorporated into the March 11th decision of the court. So now at this point you have a judgment entry of divorce that's 10 days before, signed 10 days before the magistrate who decided the case, who heard the stipulations, who references the stipulations in a later magistrate's decision. You have a judgment entry that's not signed by the magistrate. What possibly could the court have to review on March 1st, 2013 to consider the issues before the court? There were stipulations. There's no, again, there's no Civil Rule 53 waiver. There's no, not even a sign off. We don't even know that the magistrate agreed to the terms of the divorce judgment entry because there's no signature there. So I submit to the court, the important factor here is the March 1st, 2013 judgment entry of divorce is significantly different than the March 11th, 2013 stipulations taken and recorded and detailed in a magistrate's decision by the very magistrate, the very person that heard the trial. So this is extremely relevant when you consider whether or not appellant was in contempt of court, which is the January 28, 2015 finding of the trial court. You reference back to the glaring issue is the judgment entry of divorce signed on March 1st solely by a trial judge, not considered by the magistrate, contains language that says that the marital home was supposed to be sold. From the proceeds, there were certain bills, certain debts that were supposed to be paid. From the proceeds, then it reads, plaintiff gets $20,000, and then defendant retains the balance. However, the difference between the March 1st, 2013 judgment entry signed by the judge and the March 11, 2013 magistrate's decision containing the stipulated agreement is that the judgment entry requires plaintiff to pay, defendant, appellant in this case, to pay $20,000 to appellee regardless of the amount of the proceeds from the sale of the home. That phrase is nowhere to be found in the magistrate's decision of March 11, 2013.
Excuse me, let me ask you a question. Would it make any difference, though, if it said regardless or not, if wife had made the mortgage payments while the case was pending? Because there was a period of time where she didn't pay mortgage payments. Right? That's
correct, Your Honor. I believe that...
Was it $9,000, $5,000?
It was $9,000, yes it was.
And then she also didn't pay the condo association fees. That was $3,096.75.
Correct, Your Honor.
And she didn't pay the $200 August maintenance fee, too.
Correct.
So that totals $12,862.75 that she didn't pay, that she was ordered to pay in the temporary orders.
That's correct, Your Honor.
So had she paid those things that she was supposed to pay, there would have been an extra $12,000 in that sale of that house. Not to mention the $1,600 that she paid the movers.
Correct. Still deficient of the $20,000.
But it would have been a lot more than the $1,500 she actually ended up giving, right?
You're absolutely correct, Your Honor. There would also have been a lot more net proceeds had the house sold for what the parties believed. The appraiser said $234,000 was the fair market value of that house. Okay. Both of them relied on that when they made that agreement. The anticipation is clearly there's going to be enough money to do this deal. And had appellant only had what she agreed to as contained and as stated in the March 11, 2013 magistrate's decision, it wouldn't be an issue because there's a pecking order. You pay the bills. Then he gets the next $20,000 and then she gets what's left. Well, if there's not $20,000, the game's over. However, the judgment entry and divorce that's signed, again, I go back to that original point, out of nowhere, mandates her to pay $20,000 regardless of what the house sells for. The net proceeds were $3,700.
If the March 11, 2013 order, when the spousal support came out, if that became a final appealable order, she never appealed that.
That's because the court entertained objections at that time. The prior counsel filed objections to the magistrate, to the March 11, 2013 orders, and they were all rolled into this January 28, 2015 finding of the court when they overruled the objections. Granted, they did change, they didn't overrule all of the objections. They did provide some relief in terms of the purge amount, which is, the record is clear that appellant hasn't even been able to make the purge amount, even at the lower amount. But the point is that procedurally, the court didn't do what the civil rules require it to do. So a court of equity, when considering contempt, now mind you, this isn't a he said, she said, or plaintiff versus defendant, or appellee versus appellant. This is whether or not appellant's going to go to jail on contempt. So you have to find out, did she follow the court orders? The court orders are deficient. The court orders do not contain the proper language. Somewhere that language came. And I agree, it's part of a court order. But a court of equity, when it's trying to determine if someone is not following its orders, can see what happens. She saves the house out of foreclosure. The real estate market collapses. There's pests in the house, and there's radon. All of which yields the $205,000 selling price as opposed to $234,000. The bills got paid. There was a little window of her creating some gap. She pays $2,000 of the $3,700 to appellee and files a motion for relief from judgment, telling the court, look what happened. There's not $20,000 of net proceeds. I shouldn't have been ordered to pay $20,000 of proceeds because it's impossible. And in the second assignment of error contained by predecessor counsel, cites that very fact that it's one thing to have an inability to pay. That's clearly a defense to a contempt action. This situation was impossible. It was an impossibility of performance, and that is a defense to a contempt action. So I submit to the court, a court of equity has to take in all the facts. It has to see what was the activity, what was done. The house was sold, the debts got paid, she did what she could do. She asked the court of relief from judgment. Then to compound the error to the appellant, they hear the contempt motion, which was filed after the motion for relief from judgment was filed, but they hear the contempt action, and she's found in contempt of court while the relief from judgment is pending. Now, clearly, under 60B-5, that judgment should not have had prospective application. It was inequitable. There's no proceeds, there's no money anywhere for her to comply with it. And if the court, thank you, Your Honor, if the court was to say that she's duty-bound to follow the court order requiring $20,000 regardless of the net proceeds, it wasn't possible for her to comply. Then perhaps you gauge her payment or gauge her purge in another way. The court made a monthly payment, reduced the amount for her to pay. She simply can't do it.
You know, counsel, it seems to me that you're asking this court to look at the $20,000 payment and in the context of the contempt in a vacuum of sorts. But the trial court had to consider the entire property issue in fashioning that $20,000 payment that was ordered. And so it's sort of like, you're asking us just to look at the fact that the house was sold and that the net proceeds did not, come up to that amount.
I would agree with you on that's accurate, but the parties entered this agreement. Yeah. This wasn't something the court decided. This wasn't something, there's no reference in the judgment entry that it's $20,000 because this. It says $20,000 as for his interest in the house. That isolates the assets. Call it a vacuum if you will, Your Honor, I appreciate that. But this is a court of equity. They've got to take in all the facts. And the fact is, it wasn't there. And you have to, the old professor from torts class, who created the dilemma? The dilemma was created by this judgment entry that had language in it that's not in the magistrate's decision. The only person who should have been considering this issue regarding mandatory $20,000 didn't have it in his decision.
But if I may, though, there was consideration in there that it says the parties acknowledge that $18,582 to pay off those debts may not be sufficient to pay it off. So there was a possibility that there wouldn't be enough in the proceeds of the sale of the house.
All the more reason why the $20,000 requirement should not have been a part of the March 1st, 2013 judgment entry. And what's also indicative of this court's action against the appellant is the magistrate that wrote the March 11, 2013 entry that says nothing about, or decision, I'm sorry, says nothing about regardless of what the net proceeds are, requires her to pay $1,350 in spousal support and then $1,500 towards a purge. That's more than half of her gross income. Thankfully, the trial judge saw that and reviewed, not some trial judge, but the judge who reviewed the magistrate's decision saw that and reduced the purge, but that's a matter for another day, and in fact for this afternoon. But nonetheless, the bottom line is, and I realize my time is limited, but the brief references the payment, the unconstitutionality of requiring prison for a debt. In this instance, it's not spousal support, it is in terms of a property division, so it's submitted to the court. That should be vacated as well. Finally, Your Honor, I think it's relevant to the court.
And I'm afraid I have to interrupt you. All of your time has now expired.
Okay, Your Honor. Thank you. Thank you.
May it please the court, I'm David Ferguson, representing the appellee in this matter. I think counsel is under the impression we're here on an appeal of the divorce decree. We're not. That is not what we're here for. A resolution was made of property settlement and all issues except spousal support. That agreed entry was to be placed in a decree prepared by the counsel for the defendant. Well, the defendant, yes, and submitted. That was done. Counsel for the plaintiff, or counsel for the wife, indicated it had been seen but not approved and returned it. That order was then submitted to the court. If they had an objection to anything in that decree, they had an obligation to present written objections to that language. That was never done. The decree was filed. They filed a motion for relief from judgment, which was overruled, raising these same issues. They attempted to appeal that, and the appeal was deficient because it was not timely filed. That's the end of that. That judgment entry of divorce is res judicata. It's done. It's not a part of this appeal. Under that order, she had an obligation to pay him $20,000. Nothing ever says that should come from the proceeds. All the magistrate did in the decision on judgment entry is put a one-sentence summary of what what the property settlement was. It's a one-sentence summary, and it doesn't say that $20,000 should come from the proceeds of the sale. The $20,000 and was to the time the agreement was that $20,000 would be paid at that time, not from those proceeds. And what Judge Moore indicated is true. It was a total settlement. It was a property settlement that included other matters. But all of that doesn't make a difference because that's not what is under appeal here. What's under appeal here was a decision by the trial court to find her in contempt because she didn't pay the property settlement when she was supposed to pay it. That's what's under appeal, not the underlying obligation. That's finished. So I didn't hear anything in this argument except was there an impossibility of performance? And the court addressed that. The magistrate addressed it. And after the objections, the trial court looked at it and said there wasn't an impossibility of performance because of what she was earning, and it was so that's been addressed. So what we have before the court today is whether or not the trial court was correct in finding her in contempt for not paying the full $20,000 when it was supposed to be paid. That's the only issue. And whether or not there was an impossibility of performance. And the trial court specifically found there was not. Now on this issue of whether the trial court should have heard the contempt motion before the motion for relief from judgment, the rules indicate that you can apply for and receive a stay when you file a motion for relief from judgment. She didn't do that. They didn't even ask for a stay. They could have. I have a feeling they didn't, because they would have had to post a bond, probably in the amount of $20,000, so that if they lost their motion, the bond would have covered the $20,000 payment. But they didn't ask for a stay, so the trial court was completely proper in hearing that motion, even though the motion for relief from judgment was pending. And as a matter of fact, at the same time the trial court overruled the objections, they overruled the motion for relief from judgment. So that's...
Doesn't that sort of become a circular argument in that they probably did not seek to have a stay because they have to file the bond, which would have been in the amount of $20,000. If she had the $20,000, then she would have paid it to husband and would not have been in contempt. So it sort of becomes circular.
Well, the trial court found that she did have the ability to pay the $20,000. And look, this trial court has bent over backwards to give her an opportunity to pay that. In reality, the divorce decrees in the property settlement says the $20,000 shall be paid at the time the house sells. When the trial court gave her this opportunity to pay this over a large period of time, in fact, the trial court was amending the property settlement, which it didn't have the authority to do. We didn't appeal that, and it's not before you, but the trial court has bent over backwards on at least 2 occasions, allowing her more and more time to pay this. First of all, they moved it up over a year for these payments even to start. And there was no agreement that the property settlement would be made in payments. So she's been treated extremely fairly by this trial court. But they're trying to bend into this appeal of a contempt order and appeal of the decree itself. And I don't think they can do that and shouldn't be permitted to do that. So this appellant has been treated more than fairly by the court, and she should have to pay this, whether it's over time or in lump sum or whatever. Any appeal of the judgment entry of divorce itself has already been heard and decided and is not before the court.
Well, thank you. We must conclude because you don't have any time left. You used all of your time. And in fairness, I have to stick to the rule. Thank you. We will take the matter under advisement and issue a written copy of the opinion when it is finished. You may also, we'll send it to you, and you may also check the website and you can find it there as well. Thank you and have a good day.
Thank you, Your Honor.